Welcome to Come Back with a Warrant.
Hello, everyone, and welcome back to Come Back with a Warrant with attorney Michael Gottlieb. The American legal system is built on a simple premise. You're innocent until proven guilty. But in the courtrooms of South Florida, that premise is challenged every single day. For 3 decades, Michael has stood between the state and the accused, litigating over 150 jury trials in state and federal courts. From the Florida legislature to the Broward County defense bars, his work is centered on a single mission: protecting the constitutional rights that keep us free. I'm SeanOConnor, and today Michael and I are talking about why criminal jury trials can change quickly, what happens inside the courtroom that can shift the direction of a case, and why even strong cases don't always unfold the way either side expects. Michael, good to see you.
Good to see you, Sean.
I know you've got a lot of experience in this area. Why? Why can a criminal jury trial change so quickly once the evidence starts coming in?
So, that's a really interesting question. And I've had a lot of trials change. And I've spoken before, on my podcast about some of those. So, sometimes we have an idea of what the evidence is going to be, whether it's testimonial. So let's just talk about testimonial real quick. Sometimes testimonial evidence changes. You expect a witness to say something, and then they say something completely different. Could be their memory, could be that they've just changed their testimony. It really depends. I've had a law enforcement officer who, the plea offer was life in prison. The state really thought that they had my client dead to the rights. And it was a DNA case. And it dealt with 2 different pieces of evidence that were found at 2 different crime scenes. And when the officer went to testify about them, he pulled both pieces out of the same bag. And it was like, whoa, the light bulb went off to both me and the prosecutor. They've contaminated this evidence. And so the case changed dramatically. The prosecutor's jaw fell open. Likewise, I looked at him and said, I gotcha. And I wound up with a not guilty verdict after, a strong plea offer of life in prison. So the unexpected happens in trial.
Yeah, that's right. Like the human element comes into play all of a sudden. Things can go in a direction nobody expects. I definitely have heard that enough from attorneys I've spoken to. What about turning point? Like, what are some turning points a jury trial, during a jury trial that an attorney can't predict? I mean, in a sense, you just mentioned one right there with tainted evidence. So there are other things that you've seen come up?
Yeah, I mean, I've seen witnesses break down, and I think breakdown can be described in a couple different ways. Some cry, and they think that that's going to help them, and it doesn't necessarily, because juries are really looking for whether or not somebody's being honest, straightforward, credible. Some situations are appropriate to cry, but sometimes you'll have a witness cry. Sometimes you'll have a witness who, for no reason whatsoever, is combative. And the jury sees that, and they, again, it's all about the credibility of the person who's on the witness stand. And we talk about that in voir dire, jury selection. So, anything like that, jurors are watching you. They're listening to you, but they're also watching you. So, depends on your body language, what you're doing, what you're saying, can really change the momentum of a trial for one side or the other.
Yeah, again, the human element, that's so fascinating. How much, can a witness's testimony change what, sort of both sides thought was going to happen during a trial?
So I'll give you another great example where I went to trial. And literally, while we're in jury selection, before we have opening statements, we realized that the witness, this was a sexual battery trial. The victim's sister wrote a book that is identical to our fact pattern. We were able to use excerpts from the book, and I don't think the victim knew that we had that for purposes of cross-examination. I don't think the federal government knew that we had that book. I mean, we just bought it off of Amazon, right? And here we are, we're reading the book while doing jury selection, while doing our openings. When it came time to cross-examine her, and we're cross-examining her based on things that her sister wrote, which undermined her credibility. I mean, it was really incredible. You
Wow.
could see the shine come off the state's case at that point in time. I'm sorry, I said state, but it was a federal case. You could you
Yeah,
could see the
yeah.
shine come off their case, and her credibility diminished and diminished and diminished. And and again, that's just something that was like a sort of a Perry Mason moment in court, because nobody expected that to happen. Nobody knew until that instant in trial. And so that, I mean, that was a major shift in trial and in terms of how we prepared our case. And you can't be so concrete and say, well, we're just going to ignore that new fact. You get a new fact that really changes the game, you have to run with it. And we did, and we wound up with a not guilty
Yeah.
verdict, which was fantastic.
Well, and so I'm fascinated by that. So it ended up, the impact, so to speak, was that the witness was potentially kind of supplementing the story based on what was in her sister's book.
So it was really odd because it was a situation: is this life imitating art or art imitating life? You know, um, and it just became something that it really just made no sense. Like, this was a story of, an alleged assault, that she said she hadn't spoken to anybody about, yet she told her sister, and her sister published it as a book. And, y- y- you know, um, it created a financial motive, right? Like, here's a story about this assault that took place on an expensive yacht that she was working on. It gave her the opportunity to sue, and there was a civil lawsuit pending, and it gave her the opportunity to write a book. And those kind of things are what we call bias, interest, and motive. So if you can ever show, especially in cross-examination, that the witness has a bias, they have an interest in how the case should be determined, they have a motive. Juries are hungry for that motive. So when you have an opportunity to show that there's a motive, that was really a game changer mid-trial, if you will, right? Because I didn't have that in preparation, Sean. I mean, that really goes to your question, really changed everything right away.
Well, if you had had that in advance, would you have had to have shared that?
Absolutely not, because that was something they would have or should have known about. I would never have to share that I found this book. You can cross-examine anybody with anything. You can write something on a napkin, essentially, and impeach them with it. They can either accept it or deny it or explain it away.
And then this is sort of adjacent to that, I think. But like, what happens when evidence has like a very different impact on a jury than either side expected?
So you never know how. First of all, it's an that's an interesting question, because you never really know how it's going to impact the jury until you get the verdict back, right? So you're also
Sure,
trying to
sure.
read their body language. They're not often going, opening their mouths and screaming and hollering. Sometimes you'll see them cry, right? So
Mm.
you're trying to sort of guesstimate, how is this impacting the jury. You can tell, are they writing notes? Are they, I've had a juror that we saw writing notes. It turned out they were doing caricatures of the people at trial, right? And so you never really know.
They were moonlighting as a sketch artist.
Yeah, it's great. I have it hanging on the wall in my office, but you really never know how it's impacting the jury. You can just do your sort of best guess, and then hope that they're seeing it the way that you are, and then explain it and wrap it up in your closing argument.
And what about back to like the jury and individual jurors and how they react? Let's say they hear conflicting testimony or discover gaps in the evidence. What have you seen in terms of jurors' reaction in that context?
So, one of the great things about being a trial lawyer is you get to sort of explain to the jury before trial where they should look to find reasonable doubt. So you look to find reasonable doubt in the evidence itself, in the conflicts in the evidence, or in a lack of evidence. So when you have
Uh,
one of those situations where there's a conflict, right? One witness said one thing, the other witness says another. You want to play them off of one another and start to build on that as you're doing your cross examination, because the more you can sort of blow up that conflict, the more you're creating reasonable doubt, the more you're saying two people can't be right about the same thing.
Interesting. I haven't sat through that, but yeah, I love that aspect of like as a trial attorney getting into that with people.
Well, I will tell you, like, when you see the government pick their jury, oftentimes they're going to anticipate that there's going to be conflicts. So they'll give an example of like going to a wedding, right? And they'll ask a couple, you know, about the wedding. And they, you know, so the wife will say, "Oh yeah, we went to the wedding and she was dressed in white and the dress was beautiful and the flowers were this way." And they ask the husband, he says, "Oh yeah, the food was great, the liquor was great, the band was okay." Two different, not conflicting stories, but differing stories, but that doesn't mean that the wedding didn't take place. So the government also does in voir dire and jury selection, they try to tie into the fact that, look, not all these witnesses are going to say the same thing. That's why it's really important to take those, what some people might call minutia, but take those details and really show how those conflicts are creating reasonable doubt. They don't add up. The government's case doesn't make sense.
How do you, as an attorney, how do you adjust your trial strategy as new evidence or testimony comes out, right? Because I've got to imagine there's occasional surprises. You didn't know what someone was going to say or what was going to get introduced.
There's always a surprise at trial, right? Because no matter how much you prepare, somebody's going to say or do something different than you expected. And that may sound like, well, no matter how much I prepare and I prepare and I prepare and I over prepare for my cases at trial,
Sure.
to the point where everything's in your head, right? I don't have to look at notes when I go to trial. It's all in my head. I don't care how big the case is. You prepare for, months for something like this, but somebody's always going to say or do something different. It's just the nature of people, under the pressure of cross-examination, they do that. And what you have to do is not be so concrete as a lawyer, not be so concrete in your trial strategy that you're not able to, to bob and weave, if you will, with the evidence.
Yeah.
Right. Yeah, you have to. You have to be fluid.
And then the judges come into play, right? I'm thinking about, okay, there's how is like maybe a single ruling from a judge significantly affected the direction of a criminal trial? How's that work?
Well, I mean, I've had rulings from judges that have caused mistrials. Because the judge will rule one way and then one side violates the ruling. And then, again, what you have to do is you have to protect your client and you have to say, look, judge, you ruled this way. They didn't follow it. It's so damaging that I need to now
you can't
ask
get a fair trial.
That's it. You can't unring that bell. Right. So, you told them they can't do that. They did it. You can't unring that bell. That jury's heard that, can't erase it. I've had court deputies also who have had communication with the jurors that they weren't supposed to have and had a mistrial. So, you've got to be listening and paying attention to everything.
And how does that happen, Michael? Did that communication, in the case you're talking about with the deputy, did that happen in the courtroom or like in the jury room or?
So strangely enough, it was on a murder case, and the jury got to know a little bit about the facts of the case, and it was a bar fight gone wrong, and two guys were fighting in a parking lot. One charged the other. He pulled out a gun, shot, and killed the guy who charged him. Right. So it was like, in terms of murders, and maybe I'm jaded being a criminal defense lawyer, I've done it for a long time, but it was very generic, not the kind of guy that's running around hunting people and killing them. And the jurors asked the deputy at the conclusion of the jury selection, does he have our addresses? Like concerned about the defendant. And it was the way that the deputy answered the question, which the question should have been referred to the judge and should have been referred to us, because now this juror is showing a concern that they didn't express during voir dire. And, based on how the deputy answered the question, which was in front of all the other jurors, it created a mistrial because it created an impression that the client was much more dangerous than he actually was. It was a self-defense.
Got it. Oh, that's interesting. Do you have another example, maybe, where in a jury trial, the case changed dramatically once evidence was presented? Anything?
I've tried a lot of cases, but one of my favorite ones, there's two examples that I like to talk about. One had to do with duct tape, where my client committed an armed robbery, jumped over the countertop, puts his hand down, jumps over the countertop, and then takes duct tape and supposedly puts it over the mouth of the the woman behind the counter. So this is, really egregious facts, bad robbery. Somebody was essentially held against their will, duct taped while the place of business got robbed. And I really had to pay attention to the evidence. And when the duct tape was shown as it was found, I guess when they took it off the person's mouth, they balled it up. And then it was stretched out for DNA testing. And I did an entire cross-examination on not the DNA. The DNA was irrelevant, right? But what they had done was I paid attention to the testing, and they tested, when they went to arrest my client, they took a hat out of his house and they tested that item first. So they took the known DNA, tested it first, then they moved on to a second item or a third item, and then they moved on to the duct tape. And in order to test the duct tape, they had to unravel it. And they agreed, the DNA technician agreed, she never changed her smock or her lab coat. So the question was, is it possible that there was a DNA transfer from the hat, the known item first, to the fourth or fifth item that was tested? And 100% everything changed in the case right then and there. And I wound up with a not guilty because, again, it was a DNA case and the jury just didn't believe, in the government's theory at that point in time.
Yeah, and then that game within a game of like, okay, it's like the chain of evidence, the chain of custody, right? And then what happens, and like, what is the protocol inside the lab? Could something have been tainted? And
the technician had to answer, yes. Yeah, it's possible. It could have been. I don't think it was. What do you mean you don't think it was? We're here. This is science. We need to be more precise.
Yeah. There's someone on trial here. Their life depends on it. You're not sure? Okay, fair enough. But that's gonna leave a mark.
Yeah. And I've done the same thing in reverse. So just to give you another DNA, like I love DNA because everybody thinks, okay, it's the science. You can't beat the science. You can't. But humans make errors. So there was another case where it was a delayed report only by 2 weeks. And so the police said, yeah, we didn't go to his house where the attack took place. There was no evidence we were going to get there. I'm like, what are you talking about? This was supposedly a violent attack that happened at his house. You didn't check it for his house for DNA? They're like, no, we didn't, supposedly things happened in the bathroom, in the bedroom, on the floor, like 5 different locations in the house. And they didn't check it for DNA. They said, no, there wouldn't be any DNA there 2 weeks later. And I just looked back and I said, really, have you ever heard of King Tut? And you could see that's a moment where, you could see the jurors did exactly what you just did, which is like, yeah, I mean, King Tut's 3,000 years old. We know who he is through his mitochondrial DNA. So you're hoping for a smart juror at that point, right?
Yeah, sort of this conversation aside, the idea that law enforcement or whoever wouldn't go back to the supposed scene of the crime and find just in case,
It sort of underscores whether or not they even believed in the delayed report, whether or not they believed, the credibility of the reportee, that they didn't do their job, to try to bolster her story by getting, the evidence. So I was able to weave all of that in. Why not just look? Let's just go look and check for fingerprints. Let's look for anything. So yeah, it worked out. That's why I said, in trial, you cannot be so fixed on what you think is going to be the right strategy. You got to be able to, be fluid. Like I said, bob and weave, and things are going to go your way.
No, that's great. Good stories. Michael, thank you. We're out of time for this episode, but thanks for sharing your stories from the courtroom and your expertise. Really appreciate it. And I look forward to connecting on a future episode.
Likewise. Thanks for having me on.
That's it for today's episode of Come Back with a Warrant. For more resources, notable case results, or to schedule a consultation regarding your specific situation, you can visit the website browardcriminallawyer.com. You can also call 954-682-0999. Thanks for listening, and be sure to subscribe, maybe share the episode with someone in your world who would be interested in this conversation. I'm SeanOConnor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.